Good afternoon, everyone. I'm Salvatore Di Costanzo, and I'm an elder law and estate planning attorney here in Westchester County with offices in Rye and Yorktown Heights. And I'm happy to be here today to continue our weekly educational series where we have these video chats on relevant topics that I think are very useful to everyone that's listening or watching. The last couple of weeks we've invited some of our colleagues to join us, and today I'm going to go solo again. And so I hope for those of you that think I'm boring, then hopefully I can entertain you a little bit today. So please don't feel bad that there's nobody else that's going to be here with me today. But hopefully you could tolerate looking at my face for the next half hour. And hopefully what I'm going to give to you is useful information. Thank you to all of our essential workers again. Thank you for all the efforts that you've put forth. Hopefully we're moving past this, and I hope that everybody that's watching has found some degree of peace and comfort at this time. Hopefully you're returning to your work environment or whatever sense of normalcy it is that you intend to return to. It's raining here today up in Yorktown Heights, so you might hear that in the background. So I apologize for that, but I can't control the rain. So today we're going to talk about special needs trust, special needs planning. If you're someone that has, you may be disabled yourself, you may have a disabled child, you may have a disabled spouse, and there are different ways of planning for disabled individuals. And so I thought I would touch upon this because it's a part of our practice, and it could be somewhat complicated at times, and there's different ways to plan for the assets of a disabled individual. So generally, when we're speaking about planning for special needs individuals, we're going to be talking about trust. And special needs trusts are governed by New York State. They start at the federal statutes. But we actually have a particular statute in New York State that talks about special needs trust. Now, there are two types of special needs trusts that you ordinarily would run into. And let's talk about the first type. The first type of trust is called a first party special needs trust. Now, what does that mean? It means that it's going to be funded with the assets of the disabled individual. So let's talk about a real life fact pattern. A child, let's say, goes through a medical procedure, let's say, or even perhaps at birth, the child suffers some sort of traumatic injury and is disabled for lifetime. And there's a lawsuit settlement, right? There's a malpractice action, and ultimately that results in a lawsuit settlement. And now the child is going to come into assets. We may look to create what we call a first party special needs trust. That means we're going to take the assets that are being paid to that child and put those assets into a special needs trust. First party special needs trust. And that child might be receiving Medicaid benefits, SSI at some point, any type of government benefit. And if they are, the assets of the special needs trust cannot be counted against that child if it's set up the right way. And we'll talk about how it needs to be set up. So there are many different types of instances where somebody comes into money, is disabled, and wants to try to protect those assets for the future. Now, to set up a first party special needs trust, you have to be under the age of 65. And so these are some important technicalities that you need to be mindful of. You have to be under the age of 65 and disabled. And one of the primary aspects, or should I say one of the most important aspects of a first party special needs trust, is that there's something called a payback provision. And a payback provision says that when you die, when the disabled beneficiary dies, the assets in the special needs trust have to first be paid back to the government. So it could be Westchester County, whatever county, state that paid for medical expenses, usually it's Medicaid, they have to be paid back. So let's say there's $1 million in the trust, and the person was disabled for their entire lifetime, and Medicaid paid, $5 million on their behalf. When that beneficiary dies, you have to settle up with Medicaid and pay over the $1 million in the trust to Medicaid. So that's called a payback provision. So that's very important because it must be in a first-party special needs trust. In order for the trust to work, you need to have that payback provision. And a lot of people don't understand that, and it's not drafted correctly. There's a whole body of law that stands behind the drafting of these types of trusts. There are Social Security laws that we usually look at for guidance. That's too technical for today. But there are a lot of different nuances that we need to be careful about. A special needs trust can be used for many different things, right? So generally speaking, you're going to look towards government benefits to care for the disabled individual. But to the extent government benefits do not cover certain expenses, you can go into the special needs trust and use the funds of those assets to supplement, not supplant, supplement. That's why it's called, sometimes people call it a supplemental needs trust instead of a special needs trust. We want to supplement what the government is already paying for. It's not taking the place of what the government is supposed to be doing. So, you can use it for things like vacations, and there are rules regarding all of this. Vacations, you can make places handicap accessible. You might need a wheelchair. You might need a new van. There's a whole host of things that we could be using this for. But it sits there in the trust, and it can't be touched, provided it's drafted correctly. Now, that's a first-party special needs trust. There are times where we might have to go to court to set up a first-party special needs trust. The question then becomes, who can set up a special needs trust? Well, the statute says a parent, a grandparent, a guardian, or the court. But recently the statute was changed that now allows a disabled person to set up their own first-party special needs trust. It used to be that, with that restrictive statute, if you would, you could have, let's say you have a 40 or 50-year-old that's disabled, but they still have their capacity, yet they may be disabled in other ways. And they might be receiving Medicaid and SSI, and there's no parent, excuse me, sounds like there's an emergency. There's no parent to set up the special needs trust. Perhaps the parents are deceased. Usually there's no grandparent, unless you have extreme longevity in your family. And so that person is generally relegated to the court system. We would have to file what we call a petition with surrogates court or with Supreme Court to get somebody appointed as guardian for purposes of creating this first-party special needs trust. And the person would have to spend money and go through this whole entire process. So, with the help of the New York State Bar Elder Law and Special Needs section, we changed the statute. And we now have it so that way a disabled individual can create their own first-party special needs trust. That's a big deal. So that's a first-party special needs trust. Then we have something called third-party special needs trust. Right? Third-party special needs trust are trusts that are created for the benefit of a disabled person using somebody else's assets. And this is what we see a lot of. In fact, I include a special needs trust in almost all of my planning documents, and you'll see why in a moment. I'm drafting my last will and testament, or revocable trust, and I have a disabled child. I want to leave my assets to that disabled child. But that disabled child, I want to be careful, because maybe they may not have the ability to be gainfully employed someday. Maybe they need Medicaid. Maybe they need SSI. You know, maybe their disability is severely impairing their functional abilities. So, the proper way to leave assets to that child is for me to draft an estate planning document that says any assets that pass to that disabled child should pass into a special needs trust. Those are my assets for the benefit of my disabled child. That's a third-party special needs trust. The difference between a third-party and a first-party special needs trust is that the third-party special needs trust does not have a payback provision. So when I draft my estate planning documents and I include a third-party special needs trust, upon the death of my child, or whoever the disabled beneficiary is, I can leave those assets to whoever I want. I can leave them to a charity. Often what people will do is, if there's a charity that's been involved with the care needs of your child or of the disabled person, it could be any charity for that matter, you might leave that charity as the beneficiary of the special needs trust. So we do not have to pay back the government for any benefits that have been paid to that disabled beneficiary. That's the third-party special needs trust. And so, when do we know, and there's no age requirements, right? I said before you needed to be under the age of 65 for the first party SNT. Setting up a third-party special needs trust, there's no age requirement. So, when do you usually see these? Well, like I said before, I include a special needs trust, and this is where the rubber hits the road. A lot of people don't do this, and it's good estate planning. In all of my documents, I include a special needs trust, and the way I draft it, I call it a triggered special needs trust. And what it says is, any assets that pass to a beneficiary under the terms of this document who is considered to be disabled, and we define what that means, and New York State statute helps with that too. Those assets should not be paid outright to the child. They should be put into a special needs trust, which is triggered upon my death. So, I draft my will today, everybody's healthy, life is good. I have 5 children, I leave all 5 children as my beneficiaries. When I die someday, if everything is okay, the 5 kids, they inherit my estate, 1/5 each, that's great. God forbid one of my children is in a car accident or develops some other crazy illness. You don't know. We don't know today. Anything can happen. Well, my will, the way it's drafted, prevents the assets that I would like to give to my child, prevents those assets from having to be used towards that child's care. The special needs trust will automatically be triggered, and his 1/5 share or her 1/5 share goes into that trust, and it's preserved. It's a wonderful estate planning technique that creates a lot of flexibility in one's estate. We often don't use it, but it's in every single one of my documents because I never know when we're going to need to use it. You never know if one of your beneficiaries can become disabled. So it's good practice. A lot of times I draft documents for people, and they get the documents, and they look at them and they say, Sal, why do you have all this mumbo-jumbo legalese? I don't need any of this. I didn't ask you for a trust. I don't know. And the reality is that you may need something like this someday. You just don't know. So we draft them in all of our documents. When you know you've got a special needs beneficiary for sure, for certain, then you have to absolutely include that in all of your documents. And I'll talk about a will versus a special needs, a will versus a revocable trust in a moment. One of the mistakes that people make when dealing with disabled beneficiaries is that they assume that because the person is disabled, that they should not include that person in their estate plan. And so often I see parents coming to me and they have 2 children and everything's going to one child, and the common theme is, my well child will take care of my disabled child. No, that's not good planning. That is not good planning. Number one, you don't want to rely on the well child and put that type of responsibility on the well child. That well child may have a family of their own. What if that well child dies before the disabled beneficiary? What if that well child gets divorced and now your entire estate is with that well child, and who knows what's going to be left after those events happen? What if he dies or she dies and everything goes to a wife, and the wife says, to hell with, my in-law. I'm not going to care for them. That's poor planning, and a lot of people do that. So if you are someone with a disabled beneficiary and that's the way your planning is set up, or if you have no planning set up at all, you really want to get into talk about using special needs trusts. Now, I think we have a question, so let me answer that question.
Yes. Does the will create the trust or compel the executor to create the trust to disperse what they are given?
So the will or revocable trust creates the special needs trust. The language for the special needs trust is already drafted. When I draft your will or revocable trust, and I'm going to come back to why I keep saying or revocable trust in a moment. When I draft that, I'm drafting the terminology, the language for the special needs trust right there on the spot. So that's why your will might look voluminous. It might be, 30 pages, 40 pages, because there's all of these extra pages in there that probably will have no impact on your estate, but if it ever did, we want to have that language. And obviously the executor is compelled to follow the terms of the will, and the trustee is compelled to follow the terms of the trust. And if they don't, then there's legal proceedings that could be commenced to make sure it happens. Now, you hear me keep saying will or trust, will or trust. If you have a defined special needs beneficiary, somebody that has an illness that is not going away, they're going to be disabled for the rest of their life, then you know for a fact that you need a special needs trust for that person. So we're not going to be relying on trigger language, like I said before. We're not going to be relying on if somebody is disabled, set up a special needs trust. We have someone that's disabled, so we're setting up a special needs trust. You don't want to do that through a last will and testament. Why? And this is a recurring theme. You've heard me say this a million times. A last will and testament needs to be probated. You want to avoid probate when you know you're going to be setting up trusts that are going to go on for at the lifetime of a beneficiary, especially special needs trust. You do not want to be inside the courts. Well, you'll be dead, but you don't want your trustee and your heirs to have to be involved with the courts to get permission to handle the assets of the special needs trust, to account for their actions to the court. You just don't want to be involved in this process. It's highly advisable to avoid probate when it comes to drafting special needs trust. So in order to do that, I want you to use a revocable living trust. A revocable living trust avoids probate. So you set up the revocable living trust, and then after you sign it, you put your assets into the trust, you transfer the deed to your house, you move your bank accounts, you move your brokerage accounts, whatever the case may be. And now, when you die, probate will be avoided. And what that means is that, let's say your trustee now comes in, let's say you have 2 kids and your daughter's disabled, and your son as well, your son comes in, we work together, we don't have to go to the court. We open up your trust, I say this is what we drafted, special needs trust for the daughter, we marshal the assets, we make sure we have everything accounted for, we pay all of your last debts and expenses, and then we take the assets and we go set up a special needs trust. No court involvement. And then your son, as the trustee of that trust, goes on with his business handling that trust. So you do not want to be doing this through a last will and testament. Now, that's if you have a defined beneficiary that's disabled. If you don't have a disabled child, then a will is fine. And if we end up in court someday, so be it. But a will could work. Yes, we can end up in court someday, but a will could work. Revocable trusts are getting more popular today, and we're finding, especially with this pandemic, that to avoid court is a really big deal today. So revocable trusts are being considered on a much more frequent basis since this pandemic started. One more thing. I said before, your spouse can be a disabled beneficiary. So let's say we did a Medicaid planning project, husband and wife. And let's say husband goes into the nursing home. And one of the things that we're allowed to do from a Medicaid planning perspective is move all of husband's assets over to the wife. Hopefully there's a good power of attorney in place, which you've heard me lecture on that ad nauseum. So we move all the assets from the husband to the wife, who's well, and then she refuses to use those assets. This is a Medicaid planning technique called spousal refusal. And husband now becomes eligible for Medicaid benefits. Now what happens, now that those assets are in the wife's name, what happens if she dies first? Now there's a whole host of legal issues that come up with the wife dying first. But what if she dies first, and she has a will that says, I give everything to my husband? So many people have I love you wills, and they don't have trigger language for special needs trust. So what if that happens, and they never sat with somebody like me to redo their will? And when I say redo their will, I mean let's change the will to disinherit the spouse to the extent the law allows, and leave the assets directly to the kids. All of those assets will go back to the spouse in the nursing home, and then they're going to have to be spent on the nursing home, and they're going to be lost. There's some planning we can do, but that's not today's topic. So when I draft a will, a trigger special needs trust is extremely important, even for spousal situations. That way, sometimes the spouse comes to me and says, Sal, I get it, you transferred all the assets to me, but I don't necessarily want to give these assets to my kids if I die first. I want to make sure that they're there in case, what if my husband comes out of the nursing home someday? What if he needs other types of, what if? I just don't want the assets going to my kids before my husband dies. We should be setting up a special needs trust, and the assets will be protected. So these are very important topics that apply to known disabled beneficiaries, unknown disabled beneficiaries, that's the trigger trust, spousal situations. You could see how Medicaid runs right through this, and there's also taxes that run through all this. So I hope you found all this to be useful. It's a more technical topic than what we've been discussing, but it applies to many people out there, and I'm happy to share this information with you. If you found this to be useful and you're somebody that needs these services, please call me. My phone number is 914-925-1010 or 914-245-2440. You should also go on my website, Plan Today for Tomorrow. This video will be on there. You can watch it again. And there's all prior videos that we've been doing during this pandemic that I find to be very useful. And I really encourage you, and I would appreciate it if you would share this with your friends. Because the more you share this with your friends, the more information we can disseminate. And while that helps me grow my business, it does help a lot of other people out there, and we are in the business of trying to help people. So we'll be doing this again next Thursday at 2 o'clock, and we invite you to join us. We'll be talking with a colleague of mine who is a matrimonial attorney, and we're going to be talking about estate planning topics that parlay into matrimonial topics, such as divorce and separation. And that's about it. So I hope you have a good day, and I'll see you next week.